Welcome everybody to another question and answer session live. My name is Samara Belitzky. I'm an employment lawyer with Samfiru Tumarkin. I work out of our Ottawa office, and I will be here for the next half an hour or so to answer all of your questions. So please do not hesitate to send in your questions, whether it be workplace issues, severance pay, terminations, employment law, anything employment law related, issues with respect to vaccination policies. A lot of people have been asking us recently about masking policies and masking mandates now that the provincial masking mandate has been removed in Ontario. We've been getting a lot of questions about employers who have decided to continue the masking policies in the workplace. So lots of questions about that. Any questions that you have about anything related to employment law or the workplace, I'm here to answer your questions. So please don't be shy. Send in your questions. I have a few things that I had on my list of things to talk about today. If we don't get a lot of questions, or if we have time to get to them, oftentimes I get so many questions that we don't get to the things that I had on my list. But in any case, much prefer to answer your questions. So send them in, and I'll be here to answer them over the course of the next, like I said, half an hour or so. I'll get started with a few things that I wanted to talk about while we're waiting for questions to come in. The first is, as I mentioned, the masking mandate. So a few weeks ago, in Ontario at least, the provincial government removed the mandatory masking policy, the mandatory masking mandate in Ontario. Excuse me. And so what that means now is that employers don't have to have mandatory masking policies in place in their workplaces. And there are some exceptions to that in terms of the healthcare industry. But generally speaking, there isn't a requirement by the government, by law, to now have these mandates in place. So the employer doesn't have to do it, but on the same, within the same token, employers do have health and safety obligations. And so some employers have opted to keep those in place. Now, with respect to what the law says about this issue, it has to continue to be reasonable. So for the time being, if your employer, for example, has decided to keep the masking policy in place in the workplace, and as an employee, you have to wear a mask when you're at work, that would be considered reasonable, but again, for the time being. As the pandemic continues to improve, as things change, this is a situation that's in flux. And so something that might be considered reasonable today is not necessarily going to be considered reasonable weeks or months from now. This continues to change. And so with respect to masking mandates, if your employer is implementing a masking policy, or they're continuing the one that they've already implemented, as an employee, you would have to comply with that. The exception to that, of course, is if you have, let's say, a medical condition where you can't wear a mask, or you can only wear a mask at work for a specific period. Let's say you can only wear a mask for an hour or two, and then you have to take it off and take a break and put it back on because you may have a respiratory issue. Whatever the case may be, if you are dealing with a medical condition that affects your ability to wear a mask, then you would be in a situation where you need to be accommodated by your employer. And so in a situation like that, you would provide a medical note from your doctor that outlines the fact that you, because of a medical condition, you require accommodation. And then the employer must accommodate you, okay? As long as it's possible, as long as it's to the point of undue hardship, which in these cases it would be. There would be an ability in many, many workplaces to have them comply with your accommodation, provide you with an accommodation, and have you either go outside and take a break, take your mask off for a little bit, have social distancing in place, have you work from a different location temporarily. There are many options available for any sort of mask accommodations that are required. So generally speaking, unless you do require an accommodation for medical reasons, and your employer has this type of policy in place, for the time being, for right now, it would be considered reasonable, and you would have to comply with that. That isn't going to be the case come the future. In the next few weeks, in the next few months, things change. But for right now, it would be considered reasonable. So I have some questions coming in. Before I get to the next topic that I had on my list, I'll get to some of the other questions that we have coming in, and then get back to my list if we have time. So I have a question from Gilda on YouTube, who says, an employee that has worked for 6 years in a corporation, of which 1 year has been on maternity leave, how much is she entitled for severance pay? So this brings up a couple different issues. The first that I'll address quickly is maternity leave. So it's very important to note that there's no distinction when it comes to your length of service with respect to a parental leave or any other type of leave that's protected by law. So we oftentimes talk about maternity or paternity, parental leaves, medical leaves. These are types of leaves that are protected by law. So what that means is that when you're on this type of leave, your length of service continues as if you were working. And that's for the purposes of, let's say, calculating your severance. It also applies for other situations, but generally speaking, when we're looking at your length of service, it's your full length of service, including any of the leaves that you are on, because your leaves don't mean that your employment ends. Your employment continues while you're on leave, and your job is protected in the scenarios I mentioned. So when we're talking about length of service, we don't need to make any distinction between years where you are actively working and maybe other months, weeks, years where you are on a medical leave, because those years, months, weeks, days, whatever the case may be, they all count towards length of service. There's no distinction there when it comes to looking at length of service for the purpose of calculating severance. Okay. Now, when it comes to calculating severance or estimating severance for somebody, we look at a bunch of different factors. Length of service is definitely one of them, and it is an important one. But we also look at things like the person's age and the person's position. So in the case of the person that you're asking about, Gilda, it's very hard for me to pinpoint exactly what the severance might be based on only their length of service. I can absolutely give you a range. Someone in a position for 6 years, could be entitled to, for example, 6 months of severance pay in that range. It will depend on the other factors I mentioned, though. So if you want to get an idea, for Gilda and anybody else who's watching, if you want to get an idea of what the severance might be for yourself or for somebody you can always use our severance calculator online. We have a free severance calculator. You can go to pocketemploymentlawyer.ca and you can input your information and use the online service that we offer that gives you an estimate of how much severance you're owed. Now, I would caution you that, if you're not sure about your severance, the best thing to do is always to contact us, schedule a consultation with us, and then you can speak to one of our employment lawyers who can give you an absolutely accurate assessment of exactly what your severance would be based on all the different circumstances that would apply. But if you want to know what your severance range would be in the interim, go to pocketemploymentlawyer.ca and enter your information, and that gives you a very, very good estimate of what your severance would be. So Gilda, I hope that answers your question. I hope that's helpful, but you can definitely use our severance calculator and our Pocket Employment Lawyer website to get a more accurate assessment based on the other factors that we talked about, but probably in the range of about 6 months. So I have another question here from Lou on YouTube. It looks like, Lou, this might be a continuation of a question because it starts with also. So if you had tried to ask a different question first, I don't have it here. So I only have one question from you. If there was a different question you asked first before this one, please resend it because I don't have it here and I'd be happy to answer it. So with respect to your question that I do have here, it says, also, if I am on leave of absence, non-union, non-vaxxed, is it considered as wrongful dismissal or constructive dismissal, or is it the same? So I think I'm missing some information here, but I'll do my best to answer your question with the information that I have. So if you're on an unpaid leave and you haven't been vaccinated and you have been put on an unpaid leave because of your refusal to be vaccinated in a workplace where your employer has implemented a mandatory vaccination policy, as long as it's an industry that wasn't mandated by the law to have vaccination in place, and none of them are currently mandated in Ontario at the provincial level. None of them are currently mandated, but if, let's say, you were put on a leave of absence previously when there were mandates in place, that might apply. As long as none of those mandates apply to you, generally speaking, if you're put on an unpaid leave for failure to be vaccinated in the face of a mandatory vaccination policy at work, you can treat that as a constructive dismissal of your employment and you can pursue severance. So you have the option. You can accept it and wait until they call you back and essentially do nothing about it. Or you can pursue it as a constructive dismissal, consider your employment to have been terminated, and go after your severance. And that's something that if you did want to pursue, we'd be more than happy to help you with. You can contact us at employmentlawyer.ca. All of our contact information is there. You can contact us that way. You can also email us at help@employmentlawyer.ca and somebody will respond to you that way. But if you are going to pursue something like that, you definitely want to have an employment lawyer assist you with it because it is quite a complex legal issue. So that's a constructive dismissal. Now, it could be considered a wrongful dismissal, but when we talk about wrongful dismissal, generally speaking, we're talking about situations where an employer outright terminates your employment and says to you, your employment's terminated, you're fired. There's a clear-cut termination that's being expressed by the employer. And in that situation, if the employer is not offering you enough notice or severance or a combination of the two, that's where you would have a wrongful dismissal occurring. So there's a very common misconception that a wrongful dismissal means the employer was wrong to let you go. Or maybe they let you go and they either didn't give you a reason for it, or they give you a reason that is a bad reason or doesn't really make sense to you or seems unfair. That does happen quite often, and I do get a lot of questions from people about this. So that's not a wrongful dismissal. A wrongful dismissal, and this is, it has a very bad name. It should be called something else. It's very misleading, but a wrongful dismissal means you were let go and you weren't offered the proper amount of notice or severance. If you're let go and your employer does not give you what they should, they do not give you the severance that you're owed, that's when it's called a wrongful dismissal. It's not that they were wrong to let you go. It's not that they didn't have a good reason. That's not part of that claim. It's really about what are they offering you? Is it enough? If it's not enough, that's a wrongful dismissal. So an employer actually doesn't have to give a reason for letting somebody go. If it's a without cause termination, like most terminations are, and they have to give you your notice or your severance or a combination of the two, in a situation like that, they don't even have to give you a reason. They can just let you go because the way that employment works is, unfortunately, it's never guaranteed. An employer can let someone go at almost any time for almost any reason. There are, of course, exceptions to that. For example, if you're on a job protected leave, there are reasons that an employer can't use as a reason to let somebody go. For example, things that are discriminatory, like letting somebody go because of their age or because of their gender or sexual orientation. Those are things that are, reasons that are unlawful reasons for letting somebody go. But generally speaking, most of the time, an employer can let someone go if they'd like, but they have to provide the proper amount of notice or severance. Okay, so that's where we hear the term wrongful dismissal, and that's where the wrongful dismissal claim would come into play in order to assist you if you fall into that category where you didn't get what you should have. I have a question from Lauren on Facebook who says, has there been any precedent set for these suits? Is someone trying to create a law to prevent COVID-19 mandates? So I cannot speak to whether other people are trying to deal with this from a legislative standpoint in order to prevent mandates in the future. What I can tell you is there are quite a number of claims, of court cases that have been started on behalf of employees against employers who have either terminated them for cause without severance or put them on an unpaid leave, which, as I mentioned before, would be a constructive dismissal. Again, no severance. In those scenarios, there's been a lot of cases started in order to pursue severance on behalf of those people. Every case is different because every workplace is different, every employer is different, people's workplace circumstances are different. For example, some of those people have worked remotely and were let go while working remotely, others were working in person. So every single case is different and has different circumstances. And a lot of these cases have been put forward and they're now going through the court process. So there hasn't been a case related to COVID-19 vaccination mandates that has gone to court yet. And that's because it takes time, unfortunately, to go through the court system. But I can tell you that just at our firm, we have many of these cases that have been started in the last few months, and they're going through the steps, they're going through the court process to eventually get to court. A lot of these cases are likely going to settle at some point, but if they don't, they will end up at a hearing. And I know for sure that there are lots of other lawyers out there who have started cases like this on behalf of their clients. So there are a lot of these cases on the go right now. They just haven't gotten to an actual hearing yet because it's simply too soon. So we will see them hopefully start to come out of the court. We will hopefully get guidance from the court definitively on this issue in the coming months. Certainly this year, we expect that there will be these cases that do go to court, but just hasn't happened yet simply because it's too new of an issue. And it does take a lot of time to get to that point in the court process. Gilda on YouTube, I see your second question. This seems to be a complex matter. So if you are an employer, and it sounds to me like you may be an employer or you may be messaging us on behalf of an employer, I recommend that you get in touch with me directly. You can go to our website at employmentlawyer.ca and all of our lawyers are listed there. You can click on my profile. All of my contact information is there, and you can contact me directly to discuss this issue, because it does seem complicated based on the various parental leaves and the situation at hand. So it does require definitely an offline discussion. I'd be more than happy to help you and figure this out. But I do recommend that you contact me offline and we can take it from there. I have a question from Rocket on YouTube, who says, is an employer allowed to deduct from an employee's check damages or to replace lost items, whether accidental or negligence? If not, does it change if you have a contract that says you incur the cost? Incur the cost is I think what it meant to say. So in terms of damages, it would depend on the situation. So if damage is caused while somebody is in the course of their duties and due to no fault of your own, there's been damage that's been caused to company property. Usually in circumstances like that, there'd be no legal leg for the employer to stand on to deduct those damages from your paycheck, especially if you haven't agreed to anything like that in writing previously. If you were engaging in conduct that would be described as misconduct, conduct that was outside of your regular duties. For example, you may have crashed a company car because you were joyriding or because you were going, higher than the speed limit. So if you're doing something that you're not really supposed to be doing, then that would be considered something that falls outside of the regular course of your duties. And in a scenario like that, the employer could potentially have legal leg to stand on to have you reimburse the damages to repair whatever damage was caused. So there are situations where an employer could insist on that, but it really does depend on the circumstances because, again, it has to have resulted from misconduct and from conduct that was engaged in outside of your regular course of duties. If, let's say, you just made a mistake, it was an unintentional mistake while you were carrying out your job, that's not something that would lead to the employer being able to get you to pay for the damage that you've done, and definitely does not give them the right to deduct that off of your paycheck. even in a case where you've engaged in misconduct, for example, you've caused damage and the employer wants you to pay for it, even in a scenario like that, it wouldn't provide the employer the ability or the right, I should say, to deduct that off your paycheck. Your paycheck is owed for you working. It's wages that are owed to you for you working. The damage is a separate issue. So if, let's say, an employer wanted to pursue damage against an employee that was caused by the employee, that would be separate from the paychecks, from the pay that the employee is getting, and it would have to be handled or resolved separately. It can't just be deducted. Now, if you're an employee who has signed something that says that the employer has a right to deduct damages, then the employer may go ahead and do that. But just because the contract says they're allowed to do it doesn't make it so. It again depends on the circumstances. So even in circumstances where the employer would not have the right to do it, for example, and wants to rely on the contract that says they're allowed to deduct from your paycheck, again, that contract doesn't give them the right to do it just because it says it in the contract. You're not allowed to circumvent the law through contracts. So if the law says that the employer wouldn't be allowed to deduct those, they can't do it, even if you've already signed something that says they can do it. So that's how the law works. If you're in a situation like that, it's very complex. Every situation is different, and it will always depend on the circumstances of, how that damage occurred. What were you doing? Were you doing your job? Did you make a mistake? Were you engaging in misconduct? All of those questions will help assess whether the employer actually has a claim to have you reimburse, the expense of having had that damage repaired. So if you're in a situation like that, we definitely recommend that you get in touch with us so that we can assess the situation and let you know where you stand. In most cases, you won't be responsible for paying back the employer for any damage. In very limited circumstances, you may be. So it's really important to find out where you stand so you can deal with the situation accordingly. I have a question from Sam on YouTube who says, employee is hired near the end of the year, then after 1 month, they get laid off due to shortage of work. What are the options in this case? So it'll depend on whether it's an actual layoff, a temporary layoff, which is one thing, or a termination, which a lot of people refer to as a layoff, but a termination does work a little bit differently. So if it's a termination, and the employee was terminated after 1 month, they would be owed severance unless they've signed a contract where in that contract it says during the first 3 months of their employment, it will be considered probationary and the employer can let them go at any time for any reason without severance or without notice. If the employee signs a contract like that, then the employer has the right to let them go within the first 3 months without severance and without notice. That's the only situation where that would occur. Otherwise, if there's no contract, if the contract doesn't say exactly what I just said, then they would be owed severance. Now, if it's a temporary layoff, as you mentioned, it's due to shortage of work. So it very well may just be, a temporary layoff, or at least that's how it was communicated. Then the employee also has the ability to treat that like a termination of employment. So when we're dealing with temporary layoffs, most of the time, the employer doesn't actually have the right to implement the temporary layoff. The only way that an employer would have a right to implement a temporary layoff would be if it's been done before. So if that employee has been previously put on a temporary layoff and they came back to work and they continued working business as usual, that would be a situation where the temporary layoff becomes a term and condition of their employment, and it sets a precedent moving forward and allows the employer to do it again in the future. The other way that an employer would be allowed to implement a temporary layoff is if the employee has signed something where they agree that the employer is allowed to lay them off temporarily. Most of the time, it would be in an employment contract. There might be a temporary layoff clause. But again, it needs to contain very specific language. So even if you're someone who has signed something that says that the employer is allowed to lay you off, it depends on what the language is. Because in some scenarios, the language used in those clauses will not be sufficient to actually allow the employer to have that right. So it's always important to have it reviewed by a lawyer if you're in a very small a category of a very few number of people who have that. So those are the two situations where a layoff would actually be lawful from the get-go. If the layoff is lawful, then the employer has between 13 and 35 weeks to call that person back to work. And if they're not called back within that time, it becomes an automatic termination of employment. And the employee is owed severance. That's if the layoff is allowed. If the layoff is not allowed, which is the case for most people haven't had a layoff before, they've never signed anything that says they're allowed to be laid off. In your scenario that you've provided, Sam, likely the case that the layoff was not allowed to be implemented. Then in that case, they can treat the layoff as a termination of their employment because the employer has stopped them from coming to work and is not paying them. So it is essentially a termination of employment. It would be a constructive dismissal, and you can pursue severance. So if it's you or someone you know, and this is what happened to them, then certainly they should get in touch with us. We can definitely assist them, whether it's a termination or a layoff, depending on the situation. We'll definitely be able to assist them, one way or the other in terms of pursuing their rights. And if you're an employer, the takeaway for you is that you have to be very careful as well, because most employers think that you can just lay people off when you feel like it. And the way that the law works is that you can't do that. It's only allowed in very specific scenarios. Otherwise, you're exposing yourself to significant liability. I have a question from Andy on YouTube who says, my employer has increased my duties over the last year, and I am now responsible for a lot more. Does my employer have any obligation to give me a raise because of this? Okay, so this is an interesting situation, Andy. I'm going to suggest that you contact me because this is a very complex situation that would require a consultation and a discussion. But for now, because this is something that comes up often, and I just spoke with someone actually yesterday in a consultation, exact same thing, exact same issue. So it does come up very often. Generally speaking, an employer cannot significantly increase your duties. So if it's one-time increase and they're putting all these extra duties on you that were not part of your job, that are not related really to your job, and it's significant, you have the right to refuse that. And your employer cannot insist on it. They cannot force it on you. If they do, you would have the ability to treat it as a constructive dismissal and go after your severance. Now, because this is a complex situation, if you ever are going to do something like that, you want to get a lawyer involved right away. Oftentimes in scenarios like this, where people start to see changes happening at work, they get in touch with us right away, and we start to assist them in terms of how to deal with their employer and how to deal with this issue. Because if you wait and if you do nothing about it for a long time, you may lose the ability to act on it, and you may lose the ability to refuse. So as an employee, if this happens to you, or you think this is happening to you, you have to get in touch with us right away so that we can assess the case, we can assess the situation and help you. It's much better to be proactive in these situations than reactive, because there's a lot more that you can do to help yourself now than after the fact. Now, in terms of your particular situation, Andy, if it's been a gradual change, if the employer has been, very careful about not making one significant change, but over the course of a period, doing a lot of little changes, that can also still amount to a significant change and can lead to a claim for constructive dismissal when you look at it all together. But it is a little bit more complex. So again, you always need to contact an employment lawyer in situations like this so you can see what your options are. So you have to be, very careful, and you also have to make sure that if it's a change that you're not agreeable to, you express that refusal, and you do it in writing so that there can be no dispute about the fact that you did not agree to this. Because if you keep working and you don't say anything and you just continue with the changes that have been applied to you, there's what's called a deemed acceptance. And if you keep working and you don't refuse the changes, or at least raise an issue about it in writing, then you'll be deemed to have accepted the changes and it'll be part of the terms and conditions of your employment moving forward. So you have to be really, really careful with these things. Time is always of the essence. To answer your question, though, about the raise, they don't necessarily have to give you a raise because this is a situation that the law doesn't really provide for, in the sense that if they're forcing you to do something more than you should be, then the recourse that you have there is to refuse. You don't have to do those things. If you want to do those things, but you don't want to do them for free, then you can tell your employer, listen, this is not part of my job. I'll do it, but I'll only do it if you compensate me accordingly. And then you come to an agreement between the employee and the employer about what that's going to look like moving forward. So that is definitely something that can be negotiated. I've seen it many times before, but the law doesn't necessarily require it, simply because you don't have to carry out those extra duties to begin with. So I hope that answers your question, Andy, but given your situation, again, I really do recommend that you get in touch with us so that we can assist you with the situation, because it sounds like this has been going on for quite some time now. So that brings us to the end of our session for today. If I didn't get to your question, please join us. We have another question and answer session on Monday, and we have a few more next week, so you can ask your questions then. You can also go to employmentlawyer.ca and contact us that way, and we'd be happy to help you. So thank you very much for joining us today, and I hope that everyone has a great weekend.